Hello, everybody. Happy Sunday. It's Rick. It is January the 28th, 2018. If you'd like to reach me to inquire about how to receive my affidavits, my email is rick, R-I-C-K, 0327 at me.com. Excuse moi. Okay. What you're looking at here is non-assumpsit. Okay. And what we're doing with a non-assumpsit is it's something we're going to file before going to court, or if you're going to court now. Okay, now what a non-assumpsit is, let's take a look. Non-assumpsit. Non-assumpsit, okay, is a Latin term which means he did not undertake. What's an undertake? It's an agreement. It is an archaic pleading form of a general denial in action of assumpsit. It is a form of pleading in which the defendant claims that he or she did not undertake or promise or pledge any obligation in the manner or form set forth in the plaintiff's complaint. Okay? They're claiming you're not paying child support. Well, here's the real deal. Okay? They claim that you're in default. Now, you cannot be in default unless you made an agreement with somebody. Okay? You get a credit card. You make a bunch of purchases. You stop making payments. You're in default. You understand? That's what default is about. Default is a failure to perform when you're required to perform. Like when they say, well, you are required to support your child. Well, you're only required to support your child when there's proof that you're not supporting your child. So where's the proof that you're not supporting your child? Well, what they use is they claim when a woman or a man is receiving public assistance, they are receiving public assistance because of something that you are not doing. Okay, somebody reached out to me yesterday, and by email, of course, and he said that he has, he's the only father. He's got the mother of his child has a couple other children with two different men. Now, how is that woman going to claim that she was forced to go on public assistance because of something that he did when there are two other men involved? Explain that one to me. Theoretically, she could be making a lot of money just by getting support from three different men. And don't think the child support agency isn't either. They love that. Okay, think about them. They're going to be getting child support from, you know, three different men. It's a money business. But there must be proof of an undertaking. Okay. Under this plea, almost every matter may be given in evidence. Where's the evidence of the undertaking? On the ground that as the action is founded on the contract, where's the contract? The injury is non-performance or non-support. Okay, you know what non-performance is you're not, meeting the requirements of the alleged agreement. Okay, that's the injury. You see the word here, injury? Remember, it has to be an injury in every case. Okay, so here the injury is non-performance. Makes sense, right? You made an agreement, right? Let's just say you made a personal loan with a friend. You lend your friend money, and your friend is supposed to pay you every month $100, and you need that $100 because you need that $100 for your rent. But then your friend is not performing and stop making these payments, and now you're $100 light in the pocket and you cannot pay your rent. That's an injury. You understand? And if you can show proof that you're getting letters from your landlord threatening to throw you out, any type of evidence, this is when you're a petitioner, of course. Any type of evidence is important. Now remember, you're a respondent here. You're not supposed to provide evidence, but a lot of you get caught up. A lot of you are still confused with the petition or respondent stuff. And I don't know what to do about that. Seriously, I've spoken about that a lot, and I just take it case by case. Okay, you are a respondent when you are responding. And here's another thing: if you're a petitioner, it usually costs you money. So if it doesn't cost you money, you're the petitioner. And here's another thing: if these clerks are trying to charge you money to file paperwork when you're still a respondent, you better stick up for yourself, because you're not supposed to be spending money to defend yourself. Okay? Not when you're brought into court that if you don't show up, they're threatening to arrest you. Okay? So you got to stick up for yourself. All right? But that's what the injury here is. All right, so evidence which disaffirms the obligation of the contract at the time when the action was commenced goes to the gist of the action. Okay? So, if they cannot provide, but remember, the petitioner has the burden of proof. Where is the proof that you entered into an undertaking of an obligation? Now, what the courts do, not the courts, excuse me, what the child support agencies are famous for doing is we send the validation a debt letter, right? And they always respond with, well, the court ordered this debt, but here's the fact. In order for the court to order the debt, the child support agency had to provide proof of an undertaking. All right? It's like, which came first, the chicken or the egg? Well, in this matter, in order for a court to enforce a debt to a child support agency, there has to be proof of an agreement. But this is the scam that they're pulling. But now you know. I'm showing you the scam. And by filing a non-Assumpsit, we are demanding proof of the undertaking. And this could also be used to the court by saying to the court, how are you enforcing a debt if you don't have proof of an undertaking? You see? We're always getting a step ahead of these people. I'm always finding different ways to get ahead of these people. So by us filing these things, you get a letter in the mail, you got to go to court. Now, there was some fucking shitbird troll in my, you guys probably didn't see it, because that's the reason why I have to approve comments. So the last video that my subscriber Undercut 69 called up, showed you guys on the phone, and by the way, that was not pre-planned. I was laying in bed watching TV, and he emailed me, and I'm like, what's going on? He's just like, dude, email me, and whatever. You guys saw the emails. And he explained how what I've been saying to you guys in my videos over and over and over again, that it's important that you have knowledge of the law. And I'm giving you more knowledge right here. But you have to have knowledge of the law, because he threw it in their face. And he was confident because he was not asking, he was not, no maybe in his voice. He was telling them, and they knew it to be true. Okay? And what happened? $53,000 is gone. Because it never existed. Okay, this is nothing but a shakedown. And how 53,000 came from an alleged debt that arose from an alleged agreement. It didn't exist. They need consent. Okay, under 42 USC 654 subsection 3, all state child support laws are established under. Okay, and that's the reason. The reason being is that if the states want to get some of this good old federal money, they have to establish laws under that. But 42 USC 654 is voluntary by the state. So if the state's participation is voluntary, how is it mandatory for us? It isn't. They require our consent. Well, this right here is one way around it by saying, well, you know, you're called an obligor, right? An obligor is an obligation. A debt is a debt is a contract. Everything is a contract, and contracts require two parties, two consenting parties, two knowingly consenting parties, not implied, knowingly. You have to know that you are required to meet an obligation. That's the reason for an undertaking. I have you guys, some of my in my paperwork is to reach out to these to the clerks and demand proof of an undertaking. And they, 9 times out of 10, they don't even know what the hell we're talking about. But it's done for a reason, to prove it doesn't exist. That's the reason why I have you do it. Okay? All right. Okay. So the meaning that by proving that there is no existence of an undertaking, agreement, obligation, there could be no default, which is what they're claiming you're in. That's the reason why they're bringing you to court. Or injury by non-performance. See, the real reason why they have you going to court is they're claiming that you're a non-payment of support. Remember, who benefits from child support being paid by income withholding? Who benefits? We've spoken about this before. The state. Okay, Undercut 69 mentioned it in the video, in the phone call, in the video. The state benefits. Okay, that's huge. All right, so remember, the custodial parent is applying or alleged to have applied for public assistance, which is a contract with the state government, where the custodial parent is required, and it is a contract because I'll tell you why. If you go back to work, you're required to tell them. Okay? Where the custodial parent is required to sign over to the state the support rights, or whatever that means, and it's a rhetorical question, so I don't need anybody to respond. Okay? I don't know what support rights are. And you can't turn over support rights. It's nonsense, which is giving the state permission to collect debt on her or his behalf. But where's the evidence of agreement or undertaking? Okay. All right. So what we have here is a notice of court, non-Assumpsit, claimed by respondent in response to claimed indebtedness or claimed default of debt obligation. And we throw in there dismissal for failure to state a claim. Okay? Under Federal Rule 12b-6. This is what they, several of you have seen this already. It's a often used dismissal method by the courts whenever we file paperwork. Here's a little bit of information. I didn't know I was going to go in this direction, so I don't have it available right now, but I'll do it next time. When you are pro se representing yourself, which I don't like using those terms, but it's, the usage, the word usage that they're used to, or we're used to, whatever. you're giving, because you're representing yourself, you're giving first-hand knowledge. So all you need to do is provide evidence with your paperwork, and they cannot dismiss your paperwork. Okay, because you're giving testimony. Your paperwork is written testimony, and your signature is a verified complaint. Okay, because you're filing on behalf of yourself, and your signature makes it a verified complaint. Okay, and if you really want to, you on the bottom on here you could put down under threat of perjury. Okay, and then you can get it sworn in front of a notary. You're not required to get it sworn by a notary, but if if you want to, go right ahead. Okay, and you could add after your name and address, put down under threat of perjury to show them you mean business, that you're not lying, you're telling the truth. That if you're found to be not telling the truth, you could be charged with perjury. Okay, so listen. Notice to the court, non-assumpsit claimed by respondent in response to petitioner's claimed indebtedness or claimed default. We went through that up here, okay? The undersigned respondent, by filing this notice to the court, is not consenting to the court's jurisdiction for establishment or enforcement of child support arising under 42 U.S.C. Section 654.3, Title 4D. Now, what I did is, they are claiming it's for child support, and you're required to, you got to repay a debt. But we know that child support is really not child support, it's welfare recoupment under Supreme Court Blessing versus Freestone. Okay, so if it's recoupment of welfare and the money is going to the state, why are you required to pay it? Where's the proof that you agreed to receive public assistance? There is none. It doesn't exist, so it's a scam. All right. So it is a fact before the court that is supported by the conclusion of law secured by the Supreme Court of the United States, or SCOTUS, in matter Blessing versus Freestone, that state laws for child support establishment enforcement are arising under federal statute 42 U.S.C. 654.3 that were intended to benefit the states because the payment of child support by obligors and non-custodial parents are used for the recoupment of state welfare expenditures. And these payments by obligors and non-custodial parents were not intended to benefit the family or children, as obligors and non-custodial parents are led to believe and forced to comply with by these misleading laws, by forcing compliance with threats of arrest, suspension of driving privileges, ruining credit, and restraining bank account to achieve the state's Title 4D child support collections goal, so the state can be compensated with incentive payments under 42 U.S.C. 658A Title 4D, of which 66% for every dollar collected or enforced is paid to the state. But the undersigned, by pleading non-assumpsit, is informing the court, the adjudicator, and the prosecutor that he never knowingly entered into an undertaking for obligation to repay a debt with the title for the agency, and he understands that any forced payment of child support is sent to the state treasury for recoupment of welfare expenditures. That's consistent with the conclusion of law that child support under Title 4D benefits the state as secured by the Supreme Court of the United States, Blessing versus Freestone. It is a fact before the court. This court cannot prosecute the undersigned for non-performance of an obligation agreement without actual proof of an agreement or undertaking to repay an obligation. Now, all right, now we're going to go into fact of law that you're a respondent and the other party is the petitioner. What is the petitioner always required to do? We've been speaking about it for the last 2 or 3 months now, maybe longer. Provide evidence of an injury in fact. Now, or under federal law, 28 U.S.C. Section 272, okay, let me see here. Sorry about that. 28 U.S.C. Section 270, rules and procedures of evidence, power to prescribe. The Supreme Court shall have the power to prescribe general rules of practice and procedure and rules of evidence for cases in the United States. How do they do that? They do that by their decisions. Okay, that's how they do that. So how do they do that? They do that in matter, right? Lujan, Secretary of the Interior, versus Defenders of Wildlife. Remember, over the years, our cases have established that the irreducible constitutional minimum of standing, you have to have standing in court. All right? That's the reason why they dismiss paperwork for failure to state a claim, because they claim that you didn't introduce evidence to meet the burden of proof of an injury in fact. Okay? Standing contains 3 elements. First, the plaintiff must have suffered an injury in fact. Right? How many times have we said this? An actual, imminent, not conjectural. Second, there must be the causal connection, conduct. And 3, it must be likely as opposed to merely speculative that the injury will be redressed by a favorable, that they're likely to have a win. All right? So, again, we always end up here that the petitioner is always required to meet a burden of proof. We always end up getting there. Doesn't matter what paperwork we're filing. We always end up there. And that's important. Okay? If not, they're just prosecuting you without evidence. All right? And that's what we're doing. We keep hitting them up for evidence. And, right, the writ of Assumpsit is demanding evidence of an undertaking. Now, this is huge here, this law, because such rules under Section B, such rules that shall not abridge, enlarge, or modify any substantive right. All laws in conflict with such rules shall be of no further force. That means they have no force. Okay, that means that you're required to have due process. All right, and Supreme Court decisions like Lujan is our proof. Also, Murray's, right? Murray's lessee, right? It says that you're required, or does it say? The words due process of law were undoubtedly intended to convey the same meaning as the words by the law of the land. The Magna Carta, it says due process of law, the constitutions which have been adopted by several states before the formation of the federal constitution, following the language of the Great Charter more closely, generally contain the words, but by the judgment of his peers. Trial by jury. You cannot be deprived of life, liberty, or property except by a trial by jury. Okay, we always end up there, right? Don't we always end up with, evidence of an injury in fact? Don't we always end up with a trial by? These are our substantive rights secured by the Constitution. Okay, we always end up back here. It always ends up in my paperwork. And once you guys understand that you have rights secured by the Constitution and you remember these rights, you are going to be so much better. Again, my paperwork, all right, it's there. You're going to submit it, but unless you can stand up in court and be what they call a belligerent objection, the Supreme Court secures my right to a trial by jury in all controversies of $20 or more. Objection. Under the 14th Amendment, I am entitled to due process of law that prevents states from creating laws that deprive me of rights secured by the Constitution. Okay? Objection. I am the respondent. I do not have to meet the burden of proof to, I am presumed innocent. Objection. Where is the evidence introduced by the petitioner to support his or her claims? You get me? That's what you got to do. All right, so, and that's what we're going with right now, right? This is another weapon. And if you want, you could add this to your other paperwork, meaning, those of you that do your, you fix the paperwork yourself, you're doing your homework. You could add non-assumpsit to your special appearance paperwork. You could add non-assumpsit to your nature and cause paperwork if you want. Okay, because it's another due process requirement. You cannot be in violation or you cannot be guilty of non-performance if you don't know what you agreed to perform to. You understand? Everything's a contract. Okay? All right, I'll leave that here. We're at 27 minutes. That's a good time to stop. All right? And I'll talk to you guys later.